Okay.
May it please the court, my name is Scott Martin. I represent Ms. Palomares. The district court wrongly decided that Ms. Palomares was barred from safety valve relief solely because she had a prior drug offense that qualified as a prior three-point offense under Section 3553 F1B. Contrary to the district court's view, the criteria in subparagraphs A through C are cumulative. As the Ninth Circuit held in Lopez, they are not independently disqualifying. The cumulative or combination reading is supported by the plain language of F1, including the ordinary conjunctive meaning of the word and, which is unambiguous, F1's structure as a conjunctive negative proof, the context, which includes the text's purpose of giving judges discretion to sentence low-level, nonviolent drug offenders below statutory minimum sentence when they fully cooperate with law enforcement. Your Honors, and means and in the ordinary plain meaning of the word. The word is not ambiguous. As a Scalia-Garner treatise says, the word and is an elemental word in the English language that combines items. For example, everyone agrees that the and at the end of 3553 F4 combines the 5 requirements in F1 through F5 that a defendant must satisfy cumulatively to qualify for safety valve relief. Also, in Palomares Santiago, which I cited in my 28J, where the Supreme Court held that the statutory requirements under 1326 D1 through 3 are all mandatory, the court reasoned that these requirements are all connected by the conjunctive and, meaning that defendants must meet all 3. Even the Senate Legislative Drafting Manual says in a list of criteria that specifies a class of things, use and to indicate that a thing is included in the class only if it meets all of the criteria. Now, structurally, this is slightly different in the sense that its subsection F1 is a conjunctive negative proof, in which the listed things are individually permitted but cumulatively prohibited. F1 is structurally similar to the example of a conjunctive negative proof provided in the Scalia-Garner treatise, which is, quote, to be eligible, you must prove that you have not A, B, and C.
Let me ask you, in that connection, do you know of any statute that is written like this statute is that would apply the negative conjunctives to? I mean, in other words, if it's a serial line, one line like 1, 2, and 3 is one matter. But if it's prefaced by the language as this statute is, lending its words in its initial statement to the subparagraphs as well, has anyone suggested that statute is?
I'm not aware of another statute that's exactly like this. I think that what you're referring to is the government's M-dash theory. They're saying that the phrase before the M-dash should be distributed throughout the statute. That's not a fair reading of the statute. For starters, Congress knows how to distribute negative phrases when it wants to, as it did in a neighboring paragraph of the same statute, 3553 F4. That's the one that says defendant was not an organizer, leader, or manager, or supervisor, and was not engaged in a continuing criminal enterprise. Congress did not use an M-dash there.
What about M-dashes? Did it use A, B, and C in subparagraphs under the basic paragraph?
Yeah, Your Honor, in Palomares Santiago, we have that exact same structure, although it begins with unless as opposed to does not have. That's the case that I cited in my 28J, where the Supreme Court interpreted the and conjunctively. Again, with the M-dash theory that the government has here about distributing this phrase, there's no support for that theory. The Scalia-Garner treatise doesn't mention it. The only authority the government cites for that is a case called Mitchell versus Chapman, a Sixth Circuit case, but this court disapproved of that case in a case called Modica versus Taylor. And our position, which is supported by—
But doesn't the phrase defendant does not have to be read into A, B, and C? And doesn't the word and have to, that appears in B, have to apply to A and B and C? I mean, it seems to me it's very simple. I the way I would read it, it's very simple. I don't see all the fuss about it myself, but that's just me.
Well, Your Honor, it is set up as a conjunctive negative proof where the things are cumulatively prohibited. The and refers to A, B, and C. It does link them. The M dash and the and link these three subparagraphs together and show that they are a package and that the things are individually allowed but cumulatively prohibited.
But I would just read it. I mean, okay, go ahead. I don't need to get in a fuss about it.
In Modica, that was a case I discussed. That was interpreting the FMLA's definition of the term employer with an M dash, and the issue was whether a public agency employee could be held liable under the FMLA. The issue required the court to analyze the statute's definition of the term employer with an M dash, and the definition of employer had an M dash after the term employer, followed by 4 clauses numbered 1 through 4, defining what the term employer means and includes. Clause 2 said it includes individuals acting in interest of the employer, and Clause 3 said it includes any public agency. The court reasoned that the word and following the Clause 3 and the M dash following the term employer shows that clauses 1 through 4 are interrelated and not mutually exclusive.
I don't see anything in Modica that says that an M dash followed by a list can never receive the construction that the government urges in this case.
It did not say that it can never receive, but that is how it interpreted that statute. And it did say, and that is the case, Mitchell v. Chapman is the case of the government, the only case the government has cited in support of its M dash theory.
It seems to be a case where we're just looking for the least bad option, right? It's sort of like judicial selection. I mean, there's no perfect mechanism. They all have drawbacks. They all have flaws and quirks and kinks. And this is really choosing between 4 competing options, none of which is airtight. And it's really just a matter of us picking the least bad version. Would you agree with that?
No, Your Honor. I mean, I agree that our interpretation is the correct one.
The one and only correct one?
Yes, under the plain reading of the statute, Your Honor.
Well, you're talking about plain reading of the statute. The plain reading of this, I said I wasn't going to say this, but I guess I am. But the plain reading of the statute is that the court shall impose a sentence if the court finds at sentencing that the defendant does not have A and does not have B and does not have C. I mean, that's just...
Your Honor, you're adding an additional and there after...
Well, I know I am, because that's exactly the way it has to read. It has to read and has to modify the other 2 statements. It doesn't make any sense if it doesn't. It doesn't have or there. And whenever you have a disjunctive, you always have one or in a whole list of options, right?
If it's disjunctive, yes.
Yes. And so if it's conjunctive, you take the one and here that is in B that actually ties the whole thing together as and. I mean, I just can't understand the argument. Well, I mean, I understand what you're saying, but I can't understand how there is any...
It's phrased, this is the example given to Scalia-Gardner treatises. To be eligible, you must prove that you have not A, B, and C. That means you must prove that you did not do all 3.
I can understand that, because if it's a list and it says he does not have this and this and this, I mean, if it's a list of people, a list of options that go across like that, I can understand it, because there are no other words there that modify the successive options in the serial that you're stretching out. But here, you clearly have that the defendant does not have applies to A, B, and C, and the word and in B applies to A, B, and C. Otherwise, it doesn't make any sense. I mean, but that's the way you read statutes. I mean, you can't...
Your Honor, in Garcon, which has been vacated by the 11th Circuit, That they relied on a theory that this reading rendered A, surplusage, and I would like to remind the court that a conjunctive interpretation does not render it surplusage for the reasons that they gave in Lopez, which is that a 3-point violent offense can be essentially a twofer.
What did you say?
It does not, this conjunctive reading does not render subparagraph A surplusage, the more than 4 points.
People.
And that's because a 3-point violent offense can be basically a twofer. It can be can simultaneously satisfy 2 paragraphs.
So can you help me understand the textual amendment that you would have us make to C then? So I understand your point that the violent 3-point, that a 3-point offense can satisfy the 2-point offense if it's violent, but then you need to rewrite 2 to say something like a prior violent offense worth at least 2 points.
Well, Your Honor, the exact words that were used in the committee report, the Senate committee report, which Lopez relied on, was violent offense with a sentence of at least 60 days. That's the phrase that they used in the fact sheet and the section-by-section summary.
So it's interesting that you go to legislative history, because now you're telling us that it's not as plain as you said at the beginning. If you go to legislative history, I understand why you would need to do that to help us with C, it seems like each piece of what was said at the time, each piece of evidence, whether it was from the Sentencing Commission or from the bill sponsors or from the committee report, described this as some sort of modest change from the prior version of F1. Do you remember what the prior text of F1 said?
Sure. This text that we're interpreting, that we're looking at now is similar, is pretty much the same as it was in the final statute. But I think what they might have been referring to is that a provision that allowed judges to essentially waive F1's requirements if it overstated the defendant's criminal history or recidivism, that fell out. Or they could have said that this was modest because it only affected F1 and didn't affect the remaining subparagraphs, F2 through F5.
Do you recall what the prior version of F1 said?
I have it right here. Yes. Oh, the prior version. Oh, well, that was you were disqualified if you had only one criminal history.
It does not have more than one.
More than one.
So the structure, the syntactical structure of the old F1 and the new F1 keeps this does not have, but it goes from does not have more than one to this obviously tripartite list. Be an awful big elephant to bury in a really small mouse hole to say that now from does not have more than one, to this tripartite list, which, as in your view, would give safety valve relief to virtually everyone.
Your Honor, it wouldn't give safety valve relief to everyone.
Virtually everyone.
Purpose is to not bar, well, basically repeat violent drug offenders would almost always be barred, while non-violent, low-level drug offenders would not. And that's the statute, that's the purpose from the text. You can see that from the text and the legislative history. As for the argument about it being superfluous, I remind the court that that canon is a rule of thumb. It does not supersede the statute's plain meaning and structure. Congressional acts contain a lot of redundancy. There's substantial overlap between clauses is not uncommon in criminal statutes. The Supreme Court said that in Loughran. So like other canons, this canon is not absolute. Courts are not required to avoid surplusage at all costs. As the concurring opinion of Lopez said, a court could reasonably decide that the cost of applying the plain text of 3553 F1 and means and is that subsection A is surplusage. And that would be okay, because if Congress wishes to avoid surpluses in 3553 F1, it has a power pursuant to Article 1 of the Constitution to enact legislation to that effect. The court can only carry out Congress's will in applying the plain language of the statute as enacted. And, Your Honors, I believe that's correct. To the absurdity argument that the government is making, I provided Texas Brine Company case in R28J. That is a very high standard that the government can't meet. An absurdity is not a mere oddity. The absurdity bar is high as it should be. The result must be preposterous and that no reasonable person could intend. And here, none of the Lopez judges, none of them, found this result absurd. The Ninth Circuit panel included a Sixth Circuit judge sitting by designation, Judge Boggs. And there are rational policy justifications that support our reading. As Lopez observes, Congress could have made a policy decision to target violent repeat drug offenders. Also, Congress could have made a policy decision to focus that the safety valve should focus on more on the instant offense, which is addressed by the factors in F2 to F5, rather than the defendant's criminal history. And I see my time is out, so I'll save my time for
All right, Mr. Martin, we'll see you back on rebuttal. Mr. Valentini from the Justice Department, welcome.
Thank you, Your Honor. Good morning. May it please the court. Francesco Valentini for the United States. The district court correctly determined that Palomares' 2001 three-point conviction for drug trafficking made her ineligible for the safety valve. The statute's text, structure, and context established that the safety valve, as amended by the First Step Act, remains limited to defendants who do not have any of the disqualifying criminal history requirements set forth in subparagraphs A through C of the subsection. They established that the safety valve is not available to serious, repeat, and violent offenders. Palomares claims that the government's reading of the subsection is compelled by the text, that any other reading turns the word and into or, and a conjunctive into a disjunctive. But that entire theory merely sidesteps the key question in this case. The key question in this case is not whether and is conjunctive. We agree, at least as a frontline matter, that and is ordinarily understood to have conjunctive meaning. The key question is, what does the word and in subsection 3553F1 conjoin? Does it conjoin disqualifying criminal history criteria, that the defendant not have A, that the defendant not have B, and that the defendant not have C? Or does it conjoin merely fragments of those requirements? And we think that's a question that the text in the abstract does not itself answer as a matter of formal logic, as my opponent would have it. It is a question that necessarily turns on contextual and structural considerations. And those considerations, as we explain in our brief, conclusively support the government's reading of the statute. Construing 3553F1's three subparagraphs as a package will render the first subparagraph, first of all, meaningless. If a defendant has both a three-point offense and a two-point offense, then a defendant always has more than 4 points of criminal history, and that reading makes the first subparagraph of the subsection entirely superfluous, which is a textbook violation of the rule against superfluity. There is also punctuation and other structural considerations that Judge Jolly pointed to just a minute ago, the fact that the three subparagraphs are introduced by a hyphen. They're broken out into different subparagraphs. They're separated out with semicolons, and they are introduced by independent enumerating letters.
And they're joined together by a conjunction. I mean, is what I'm saying, and the word and applies as if it, were or in any other, in a disjunctive, in a statute that is intended to be read disjunctive, the word would be or. But you've got to have all of these, and this, and that, and this.
Correct, and as I mentioned a minute ago, the key question in this case is not whether the word and is conjunctive or disjunctive in this case. We agree as a frontline matter that as a top-line argument that and in this case has conjunctive meaning. The question is, what does the word and conjoin? Does it conjoin merely snippets of fragments, if you will, of those requirements, or does it conjoin full-fledged requirements that import the prefatory clause does not have? And our view is that that it's the latter, and that view is supported by all contextual and structural considerations that we point to in our brief that we just discussed, I just touched on a minute ago. But the key point, Your Honor, is that both readings are conjunctive. We also do have a backup argument where courts have, in some instances, recognized that the word and similar conjunctions can be interpreted and disjunctively and or conjunctively, but that is only a backup argument that courts have recognized. Our frontline argument here is that and is conjunctive under our interpretation.
Counsel, when we're talking about the structure of F, I'm struck by the difference between the way Congress structured F1 versus, say, F3. So F3 says the offense did not result in death or serious bodily injury to any person. So Congress could have written F1 the same way, right? They could have said the defendant does not have A or B or C, just like they did in F3, and they chose a different structure to it. What, if any, meaning do you impute to the structural distinction?
We impute no meaning to that, and the reason is, there are several reasons for that. First, the presumption that, or any preference for interpreting similar structures portion of a statute the same way does not apply when portions of a statute were enacted at very different times. F3, if I remember correctly, was enacted in 1994 as part of the Violent Control and Law Enforcement Crime, I believe the name of the statute was. The amended version of F1 was enacted in 2018 as part of the First Step Act. And in addition, I think that there's other, aside from the temporal distinction, there is structural distinctions on the face of Congress's drafting choices. In 1994, as in F3 and in F4, Congress chose a drafting strategy that basically wrote out the entire condition in a single paragraph and deployed the distributive clarity by using different language. For instance, F4, I think I'm referring to now. In the context of F1, Congress, a very different Congress, decades later, took a different approach, but that doesn't take away from the clarity of Congress's drafting decision in F1 in this case.
Let me ask you, in the construction or the interpretation of the statute, after the completion of subparagraph A, there is no and there, and I am supplying the and there because it leans on the only conjunctive or the only connective or disconnective word in the body of it, and it's and I don't see why if you and belongs after the word guidelines in A. Am I wrong about that? I mean, what is the principle that says that the way the statute is written, that and does not belong after the semicolon in paragraph A?
Yeah, no, absolutely. And does belong in that. And the fact that...
That if you read it that way, if you don't have this and this and this and this, you qualify.
Right, meaning that the prefatory clause does not have, is distributed. If the defendant must not have any of the requirements in order to qualify. That is exactly our position.
If you don't have this and this and this, if you don't have it, these three things, you qualify. I mean, I don't...
Right, but the defendant must not have any of those. Yes, absolutely. That is our reading of the statute.
If you don't, I mean, it's written in a
negative
sort of way, but it's the simplest way to interpret it is, I think, is the way that I've said it, and I wouldn't go into all of these other disjunctive and conjunctive negatives and all of that. I would just read the thing like it's supposed to be read, I think. I mean, I think that's the way you'd all read every statute that is written like this. I can understand if it was written in a serial and you didn't have basic paragraph that has to modify or that has to give meaning to the subsequent parts of the subparagraphs. I would agree, but the way the statute is written, you just read what is in the main paragraph into the subparagraphs. Otherwise, it doesn't have subjects and verbs and all that are necessary for any kind of interpretation.
That's right, Your Honor, and that's what the point we were getting at before when I mentioned a couple of times now that the key question is whether what does the word and in the subsection conjoin? Is it fragments of a requirement or is it like full-fledged requirements? And it is the full requirements, as Your Honor just described. One point that I wanted also to touch on that my friend on the side mentioned, he referenced a committee publication that was referenced in the footnote in the Lopez decision by the Ninth Circuit. I would urge the court to well, first of all, that publication was not even a committee report. It certainly cannot replace and supersede the meaning of the actual text of the statute. And even within the hierarchy of legislative history, that was not a committee report. It was an informal publication, explanatory publication, which is probably towards the bottom of the in the weight scale that courts, to the extent that they look to legislative history, accord to legislative history. But even on its face, I do want to point your honors to the actual sentence, the entire sentence that is an issue in that footnote, or is referenced in that footnote, and that my friend on the other side just mentioned an argument today. The sentence says, offenders with prior 3-point felony convictions, sentences exceeding 1 year and 1 month, or prior 2-point violent offenses with sentences of at least 60 days, will not be eligible for the safety valve. And then it goes on to discuss a waiver that was then ultimately not part of the enacted statute. So that sentence, that explanation that is mentioned in the Lopez footnote, and that my colleague mentioned today, actually squarely forecloses their reading and endorses their reading of the government.
The so-called distributive approach that the government favors, adopted by the Sixth Circuit in Mitchell v. Chapman, correct?
Yes.
Opposing counsel says that we're bound by Modica v. Taylor, which he argues rejected that approach, that interpretive approach. And tell me why you think Modica doesn't bind us. How is it distinguishable and doesn't really have any weight?
Right. So the question at issue in Modica was merely the interrelationship, whether the fact that a party qualified as an employer under one subsection would also qualify, would foreclose them for qualifying as under a different subsection, or whether one subsection modified the other. That's a question of interrelationship, as this court said in Modica. And it's not a question of distributive versus package reading. There was no question of whether all requirements had to be met at the same time in order to qualify as an employer. The requirements are clearly disjunctive. The only question was whether one subsection could modify the other, meaning whether the fact that a public entity could be an employer meant that anyone serving on behalf of the public entity, the individuals who were parties in that litigation, could also qualify as employers. So that's a question of interrelationship between the subsections. It was not a question of a distributive versus a package reading of the statute, which is what is at issue here. Unless your honors have any further questions, I did want to touch very briefly on the results that, some of the results that would flow from the defendant's interpretation of the statute, because we think they are highly irrational and probably meet and exceed any standard of absurdity. Requiring the combination of all criteria as a package will result in this sort of hodgepodge criminal history profile that really does not make sense, would not have made sense for Congress. Congress, it is true, intended to expand the safety valve, as Judge Oldham, I think, alluded to a minute ago. Any of the readings in this case would significantly broaden the safety valve. But Congress was also, in the legislative history, shed some light on this. Congress was careful not to endorse the broadest versions of the broadest broadenings of the safety valve. For instance, it did not include a waiver which would have allowed district judges essential unbound, well, much more significant discretion to bypass any criminal history eligibility requirements. And Congress did not make that part of the statute. There were other proposals on the tables. On the Smart Sentencing Act was one bill that was proposed at some point in the 115th Congress that Congress did not enact. That too, I think, had a even broader safety valve expansion. And some of the statements by the sponsors and the relevant lawmakers confirmed that what Congress enacted with respect to the safety valve was a consensus, a compromise broadening. And as to the consequences of the reading that my friend on the other side urges, they would be absurd because, for example, they would not, a defendant who has a conviction for drug trafficking, a 3-point conviction for drug trafficking, and also a conviction for murder, violent conviction for murder, presumably a 3-point offense given the kind of sentence that would result, that defendant may well qualify because it does not have a 2-point violent offense. But the same defendant, if he's convicted of drug trafficking and voluntary manslaughter and assuming voluntary manslaughter, this is granted probably a bit far-fetched, but if it resulted in a sentence of between 60 days and 13 months, the defendant would not qualify. So that is upside, that result is upside down. And there was some debate in the 28J letters about what is the standard for absurdity. That is an absurd result that Congress could not have intended. Unless your honors have any further questions.
So I know you represent the government, but you've got to admit, right, this is a pretty poorly drafted statute, just between us, right?
You don't represent Congress, do you?
The statutes can often be clearer than the final product of Congress's legislative process. But what we don't think we have in this case, Your Honor, is we have a situation in which the formal logic of the text does not resolve the question, the and versus the or, but once the contextual and structural considerations are taken into account, and for those who are interested in the legislative history are taken into account, I think the meaning of the statute is decisively unambiguous. Having said that, Congress could always be clearer. We would welcome that, but that is the statute that the courts have to interpret.
All right, fair enough.
I have one quick question. I have one textual question. What do you make of the fact that A says more than 4 criminal history category points, and then B and C talk about a 3-point defense and a 2-point defense? And the reason I bring it up, this is not an argument, as I understand it, that your friend on the other side has made, but the textual distinction between A, the way A is written, and B and C is written, strikes me that it could obviate any superfluity concern, because you could have, for example, one sentence that involves 2 offenses, right? So it says a prior 3-point defense and a prior 2-point defense. So you could have committed in a single transaction both of those, but it would be treated as a single 3-point sentence. Does that make sense? So you would have, imagine you commit felony A and felony B. One is violent, the other is not. So that satisfies those 2 offenses. But the judge imposes a single sentence of, say, 10 years, right? That's a 3-point, obviously, that would be a 3-point criminal history category score. So it obviates any superfluity concern if you have 2 offenses treated as 1 sentence. Do you see what I'm getting at?
I believe so, but I believe at that point the criminal history category as computed by Congress will still be, those 2 will still result in 3 points of criminal history.
Right, so you wouldn't meet A, right, because that requires 4 or more. But you could easily do B and C with 2 different offenses. You could have 2 different offenses. So they say, oh, one offense can satisfy both, and that requires some textual gymnastics that I talked about with your friend earlier. But you could have 2 different offenses treated as 1 sentence, right? The guidelines do this all the time, as I'm sure you're aware.
Yes, but I think the offense, the reference to offense appears to be a reference to offense as a single offense or group of offenses, right? Because the guidelines also have very complex grouping questions and grouping rules. And it appears that the reference is not just to a single count of conviction, but it appears to be a reference to an offense, meaning a group of convictions, which in that case would then sort of stretch across all of the offenses.
I don't know. I mean, if you imagine someone bringing a gun to a drug deal, right? Those are 2 different, imagine it's a felon too, right? So those are 2 different offenses. There's the gun piece, and then there's the drug deal piece. That would satisfy B and C, but if you only get 1 10-year sentence for that crime, then you have 3 criminal history category points, and you don't satisfy A. So it seems to give meaning to all 3 of the various subsections without rendering any of it surplusage and without requiring, as your friend on the other side was, I think, trying to deal with, having to amend subsection C with using legislative history.
But, Your Honor, in that case, you will not satisfy C because you want to have a 2-point violent offense, right? You will have to, because the B and C are the 2-point offenses, the 3-point offenses are mutually exclusive. You cannot have a sentence that satisfies both of them, right? Your Honor's example would, I think, have some purchase if there was, suppose, a hypothetical statute in which B said a 3-point offense and C said a different 2 or 3-point violent offense. But because the 2-point offense category and the 3-point offense category are mutually exclusive. I don't think there could be a situation in which one could satisfy both B and C. Those require two offenses, and they require two offenses that get separate, that receive a separate treatment under the guidelines. And that does render subparagraph A superfluous, because every court that's considered this as, well, the 11th Circuit did, and so did Judge Mylan Smith in his partial dissent. Unless Your Honors have any further question. And of course, the defendant has now raised the precise rebuttal and argument with respect to superfluity that Your Honor just mentioned. Unless Your Honor, the court has any further questions, we would ask the court to affirm the judgment.
Valentini, thank you very much. Mr. Martin, you're back on rebuttal.
Judge Will, this goes to your question where you were asking about your choosing between bad options here, that this may be an ambiguous statute, we're choosing between bad options. Well, if after consulting all the traditional canons of statutory construction, you're left with an ambiguous statute, you should apply the rule of lenity. The Supreme Court said so in Shular, and we've also cited Santos and Barrage, which say the rule of lenity requires ambiguous criminal laws to be interpreted in favor of defendants subjected to them. This, of course, begs the question of how much ambiguity. The Scalia-Garner's treatise's preferred criteria is whether, after all the legitimate tools of interpretation have been applied, a reasonable doubt persists.
Do you think it's reasonable to interpret this text to provide safety valve relief to a capital murderer?
Your Honor, first of all, that a capital murderer would have to meet all of the requirements of F1 through F5.
Just one capital murder, and imagine it was 20 years ago.
Well,
so if it was capital murder 20 years ago, he doesn't meet any of them, does he?
Our reading would allow for one violent three-point offense you to still potentially be eligible under F1. Then you have to go ahead and meet all the remaining requirements.
How does my capital murderer meet all three of the requirements in F1? So he has 0 criminal history category points, right? Because if the felony was more than 10 years ago, it doesn't count for criminal history.
Oh, okay.
So that's zero. That's 0. I suppose he would meet the 3-point offense, but he wouldn't have a violent 2-point offense.
He would not, but our interpretation is that the 3-point violent offense can count as both.
Okay, so it meets B and C, but it doesn't meet A.
Does not meet A.
So he gets safety valve relief under your view.
No, Your Honor. He has to meet all the remaining requirements of F2 through 5.
But none of those have to do with the criminal history. I'm not saying the current offense is capital murder. I'm saying 20 years ago, our hypothetical defendant...
He would not be disqualified under F1. But even then, judges sentencing defendants with aggravated criminal histories, including your capital murder example, must still consult the guidelines and 3553A factors and select a sentence sufficient under 3553A, which could possibly be a sentence at or above the otherwise applicable mandatory minimum. So if the government believes a sentence is too high that's imposed, whatever that sentence is, they can appeal. And our position is that judges imposing reasonable sentences is no cause for concern. So back to the rule of lenity, Your Honors, the Scalia-Garner treatise says, we believe when the government means to punish, its commands must be reasonably clear. When they are not clear, the consequences should be visited on the party more able to avoid and correct the effects of shoddy legislative drafting, namely the Federal Department of Justice or its state equivalent. There was a question about interpreting the text, whether, and this is discussed a little bit in the Scalia-Garner treatise and also in the government's brief, at least the government hinted at it, is this principle in symbolic logic that not A, B, or C means not A, not B, and not C. Well, that doesn't apply here because the text doesn't include the word or, unlike the forfeiture statute that's at issue in the Rolls-Royce case, which the government cites in its brief. So that doesn't even come into play. One more point I'd like to make is there are some old cases cited in the government's brief from the 1980s, the 50s, even going back to the 1860s, where courts thought it fine to construe and as or and vice versa if ordinary meaning would frustrate clear legislative intent. And, in this case, we have argued that ordinary meaning does not frustrate clear legislative intent. In fact, it is consistent with legislative intent. But the Supreme Court has had a lot more to say about statutory interpretation since then. In Bostick, the court said that legislative history can never defeat unambiguous statutory texts. So I don't think we should be carving out special exceptions for words like and or, which are elemental words of the English language. As the Supreme Court said that after exhausting all the textual and structural clues that enables the court to resolve the interpretive question put to us, our sole function is to apply the law as we find it, not defer to some conflicting reading the government might advance. Again, the sky will not fall if you read the statute the way we are proposing. Violent repeat drug offenders will almost always be barred under F1. Defendants are not automatically eligible. They meet F1. They also have to meet all the remaining requirements. And even then, the judges still have to consult the guidelines and 3553A. So we ask Your Honors to please rule in favor of Ms. Palomares and vacate the sentence. Thank you.
All right, Mr. Martin, thank you. Thank you both. The case is submitted. And as soon as y'all clear out, we'll